Good morning. I think I take it that I'm ready. So welcome to the second panel of this great conference. I hope that it will be as interesting and as is it on?
No.
Or use the question?
No, you don't need to turn it on because well, sorry, people can't hear you, but otherwise the owl is the microphone.
Okay. Oh.
So you just need to project.
Project. Okay.
Thank you. Speaking from a
So-
cloud student.
So in this panel, we have two great scholars. This panel is called the modernized ECT and EU law. And we have the two great scholars here. That's Konstanze from Papp, who's professor at the Hamburg University of Applied Sciences, and Ankersmit, who's assistant professor in European law here. And without further ado, I give the floor to Konstanze to start.
Yes, thank you very much. I hope I can project enough for me to be audible. Very good. I followed the discussion previously with great interest, and I think we have shared all common values like climate change is important. We need to move on to a more sustainable, policies on national and international level. We've agreed on aspects of transparency being important, social justice, I heard at one point. And we were very critical about ISDS, about investment arbitration. One of the last interventions said they are not doing a good enough job in terms of taking on environmental concerns as potential bases for justification. I now want to turn to the case law of the Court of Justice of the EU and ask the question, is the Court of Justice of the EU doing a good enough job in terms of these values? Yeah, is he concerned about sustainability, transparency, social justice? I try to share my slide. And you can see from my title that the short answer is no. The Court of Justice is concerned about the question, who decides these disputes arising under investment treaties, arising under the Energy Charter Treaty? Who decides these questions? Arbitration tribunals or the EU courts, meaning member state courts, and finally with the last authoritative word, the Court of Justice himself. And I have tried to, oh my God. I'm not the technical super guru. So these points I want to raise, I want to reach, you can see them on the slide. I want to focus on the situation as it stands now. So the question, what problem has EU law created for international law, for cases under the Energy Charter Treaty as it stands, notwithstanding that there may be reforms at one point, but what problems do we have now? And it's basically a power clash between the jurisdiction, so the competence of arbitration tribunals to decide these cases, and the power of EU courts to have a say on these cases. And I will make the argument that this jurisdictional problem, that this jurisdictional conflict is homemade by the EU. We could have avoided it and moved on to more substantive discussion involving values like we've discussed all the time. We were concerned about substance. None of us is that much concerned about purely formal things. I might also add that I'm in the camp of people who don't think ISDS is the root of all trouble at this stage, maybe. There are things wrong with it and need to be improved. But if we focus on ISDS as the root of all problems, we miss other important problems. That is my general view. So I've said this was a homemade EU problem. The line of cases I'm going to quickly look at are Komstroy being on point, saying intra-EU arbitration under the Energy Charter Treaty is against EU law. So EU law precludes such cases being heard by investment tribunals. That in turn relies heavily on the reasoning in Achmea, which was on bilateral investment treaties between EU member states. And that in turn dates back to opinion 213. So there's a whole bunch of cases about what EU law means for international law. Opinion 213 was sort of a culminating point. That was about the accession or the lack of possibility of acceding to the European Rights Convention for the EU, since the draft agreement at the time, the court found, did not ensure EU autonomy, and that is the fact that EU law will be interpreted in a way that is in conformity with its structure and objectives. So opinion 213, in my point of view, is the root of the problem. I think that went one step further than the case law at this time, and I will explain this. EU autonomy in this sense was implicitly judicial autonomy, because who is tasked with interpreting EU law? It is the EU judiciary. So in a sense, the autonomy of the EU courts is being preserved by this decision. And I said this went one step further than established case law at the time. Why was that? So we have Article 19 of the Treaty on European Union that says it's the sole responsibility of the Court of Justice to interpret the treaty. And member states have to respect this exclusive jurisdiction of the Court of Justice. That's in Article 344 of the TFEU. The reason being, member states can bring EU law-related issues only before EU courts, and in last instance, before the Court of Justice. So this exclusive jurisdiction of the court was stretched one step further in this opinion, because the court effectively held that even the preceding question of whether an EU law or whether a dispute is related to EU law, even this question is a question for the court to judge. So whether a question comes within the scope of EU law is a question that only the Court of Justice can decide. And I have the quote on the slide. So in principle, the court said, we are open for the EU to accede to international law agreements. We accept in principle external control mechanisms, but this can't lead to the effect and can't have the consequence that this external control mechanism questions the court's own findings regarding the scope of EU law. And that, in my view, was really the killer at the time. And that lies behind the reasoning now in these investment treaty cases. But we find it in an opinion on a human rights treaty. So APEA relies on this, because remember I said it's the EU's or the Court of Justice's own responsibility to determine the scope of EU law. So the mere possibility that an issue engages questions of EU law makes this issue or makes this dispute into an EU law related. So there does not appear to be any stopping line. So, and on the basis of this reasoning, in ACMEA, it was easy to argue that it's a problem concerning the exclusive jurisdiction of the court, even in investment treaty cases, which on the first look on them don't necessarily involve questions of EU law. Yeah, but because they may be EU law related. So that's enough for Article 344 to apply. And then it was just two more prongs that were needed in this argumentation. First prong, and that means that also disputes between a member state and an investor reach the exclusive jurisdiction, because states are not allowed to offer arbitration in an investment treaty. Yeah, that's an EU law related dispute that can't go to arbitration. The state must not offer this to go to arbitration. The state is under an EU law obligation to bring this before EU courts. Second prong, and arbitration tribunals are not EU courts. They are not a court or tribunal of a member state. So they are not part of the EU judiciary. So in fact, the exclusive jurisdiction of the court is breached, because they're trying to bring an EU law related dispute outside EU courts. And Komstroy, on point of the Energy Charter Treaty, just extended this logic to the mixed agreement, a multilateral agreement to which the EU itself is a party, based on these arguments, because you can hardly get out of them. Yeah, the logic is compelling step by step, but even though I will show in a moment how you could challenge each of these steps. So that's why I say it's a homemade problem. And we are in a situation now that was not unavoidable. So apart from Opinion 213 being already the first killing stone, even if we think every dispute is EU law related, that does not necessarily mean there's a breach of the court's exclusive jurisdiction, because we could have construed Article 344 of EU more narrowly and said it only covers state-to-state disputes. It does not cover disputes between one state and one private party. And even then, would there not have been necessarily a breach of EU law, because there was an argument that the Advocate General had actually picked up on. With some generosity, we could have extended some of the court's cases earlier on regarding the definition of what constitutes an EU court, a court or tribunal of a member state. So with some generosity, one could have said we include arbitration tribunals. That would have meant arbitration tribunals can make preliminary references on questions of EU law to the Court of Justice. They are hence part of the EU family, the EU judiciary. So member states can offer to bring even EU law related disputes before arbitration tribunals. So the upside of such an approach would have been we would not be stuck in a situation where arbitration tribunals lack competence to hear these cases. But we could deal with these cases in substance, because we can bring any EU law related questions before the Court of Justice. And now I've just 2 bullet points. I'm not going into them. Some examples for substantive issues, EU law issues that remain open until today, although they keep coming in these cases. So we don't know exactly how we deal with treaty conflict in terms of the Energy Charter Treaty and the EU treaties. We are still not sure about the scope of EU law. How far does it reach? We skip this because we say everything is EU law related, because it might be raising EU law issues. And we don't know about substantive EU law principles like non-discrimination and how far do they reach. So that's all open, and it would be fortunate, I think, to have some answers on this. But we don't. That these cases are dealt with on the level of jurisdiction. Arbitration tribunals lack, as a matter of EU law, they lack jurisdiction to hear this case. So we should remember, and when we think of what does that now mean for these cases, there are pending cases, there are existing disputes under the Energy Charter. What does this now mean? It's not great, short answer. We should bear in mind that these EU law, this interpretation of EU law binds the EU member states in the first place. It impacts on arbitration tribunals, but in the first place, it binds the member states. So arbitration tribunals, pre-Komstroy, have first decided to make distinctions, to say ACMEA is bilateral treaties are a different thing than the Energy Charter Treaty. That is now no longer possible. So arbitration tribunals now have 2 options, I think. They can take a political stance, and I will show examples in a moment. And they can take a bold position and say, we don't care about EU law. We decide the cases under international law. Or they can be more accommodating and say, we try, even under international law, to incorporate EU law, to make way for these EU law concerns. Now, taking these in turn, the first, purely international law perspective, for example, was taken by the Vattenfall Tribunal. So that was pre-Komstroy, but I think it still holds as a possibility. That tribunal referred to the Energy Charter Treaty's provision on competences, on jurisdiction, and said, look, it's in the Energy Charter Treaty, unconditional consent to arbitrate. And there would have been the possibility for the EU to put in a so-called disconnection clause at the time that was discussed, but it was not done in the end. So all we can do as an international law tribunal, we need to interpret this provision. And that's the basis for our jurisdiction. And it says unconditional consent. If there's a problem with the EU law, that's for the EU to resolve. But that's a position that is still possible, I think. And we will go in a bit detail with this later. Second possibility, recent case in Green Power against Spain. Tribunal post Komstroy was more compelled to find a way out, to try to realize that under EU law they don't have jurisdiction. But still they had to use this as they had to put that into an international law argument. So what they did was they looked at contemporaneous documentation at the time and said, that is enough for us to see that at the time they were trying to get in the disconnection clause. So what they really meant, both EU and its member states, was not to give unconditional consent. What they meant was to give unconditional consent in all other cases but intra-EU cases. So that's the second possibility. Arbitration tribunals actually saying, okay, we decline jurisdiction. There was no consent between EU member states and EU investors to arbitrate. Now, as much as I'm in favor of trying to accommodate international law and EU law, I think it's the right approach and principle to try to bring these regimes together. But as much as I appreciate that, I think here doctrinally we run into trouble because the treaty provision of the Energy Charter Treaty does say unconditional consent. So there is unconditional consent as a matter of international law. You can't get around that. I think you can't achieve the opposite result, no consent, by relying on other documentation. Yeah, but the clear wording of the text has to take precedence. However, on the other side, it also is a clear breach of EU law. That much we know from the Court of Justice case law. Yeah, so there's unconditional consent under international law, but in breach of EU law. I said earlier on, this breach is for the member states to remedy. Yeah, so EU law duties go to, they bind the member states, in particular the member state courts. So they would have to put that right. Not necessarily the arbitration tribunal. So I think the better approach in Green Power finally would have been to say, look, we are asked to render an award intra-EU. This award will be enforced in the EU. As an arbitration tribunal, we are under a duty to use best efforts to render an enforceable award in the end. And we can't do that if that award is going to be enforced in the EU. An EU member state court will say, look, it's against EU law, we can't enforce it. So doctrinally, I think that would have worked a bit better. We would still have the same result. But I think under EU law, together with arbitration law, that would be the best combination. Now, I said earlier on Vattenfall, the first possibility is also still an option in my view, and I'll now explain why. I think if there is a chance to enforce the award outside the EU, or if we even seat our arbitration outside the EU in the first place, this best effort duty of the arbitration tribunal to render an enforceable award would be fulfilled. The tribunal could say, well, we can render an enforceable award. It will be enforced in the US or in the UK or wherever. So in such a scenario where that's possible, yeah, where the parties plead, we whatever their assets in this or this jurisdiction, we will enforce against these assets, or when they seek the arbitration outside the EU in the first place. Arbitral tribunals could use this bold stance and say, look, we are an international tribunal, we decide on the basis of international jurisdiction, and we render an enforceable award. The consequence of this, of course, from an EU law perspective, is dire. That's an incentive for arbitration users to flee the jurisdiction, to go elsewhere. That's my big question. Is that really what we wanted to happen? That I said earlier on, the Court of Justice is taking this power approach. That's the search for control. That's the opposite result. People fleeing the EU to arbitrate elsewhere. And I want to pose the question of that is really in light of what we said earlier on, the values we want to protect, the public interest that the EU set out to protect when it came up with its new investment policy, I think following 2009 and the TTIP discussion 2015, it was all set on we'll do it better than the member states. Now, are we on the right track here? And I seriously doubt it, because pending cases, suddenly arbitration tribunals decline in jurisdiction. Pending cases will just get settled. Settlements will be confidential. In the longer run, arbitration users might prefer mediation over arbitration. There's your lack of transparency again if people mediate instead of arbitrate. We had earlier on, we started this discussion about whether arbitration users will simply go to domestic court. I think that was the whole idea, that people will then go to courts. But people who use arbitration, they also want to be in control of what they're doing. And they are in control if they can avoid certain jurisdictions. They're in control if they can select their judges. They're in control if they can have a say on how they want the proceedings to take place, where to take place. And they want to be in control as well. So I have my doubts that they will all go to public courts now with their cases. So just as a challenge to what are we actually doing here, is that going in the right direction or not? So I think the case of the court has set us off in the wrong direction. And this overall goal of achieving the public interest, aiding this public distrust in arbitration, that we're not going to achieve it, we're going to jeopardize it with what we're doing at the moment by simply declining arbitral jurisdiction. And that was on this dire note I end. I look forward to the discussion. I think we need to move away from this jurisdictional power thing. Yeah, we need to move on to the substantive issues, ask ourselves, ISDS, be that as it may, we need to improve it, we need to reform it, I'm all for it, but we need to move on and ask ourselves, what would serve the public interest best in substance? What kind of power, how do states need to exercise their power, how do we phrase this in treaties? And that's the discussion we need to move on to. Thank you very much.
Thank you very much, Konstanze. I think I can just give the floor directly to Lawrence. Okay.
Okay, thank you, Geraldo. And thank you also for inviting me to speak today. I'm going to be speaking about EU law and the power to withdraw from a mixed agreement, which is rather topical, as Christina already introduced at the beginning of this conference, given that 5 member states have politically committed to withdraw. So that's France, the Netherlands, Poland, Spain, and Slovenia. And of course, Italy has already withdrawn from the Energy Charter Treaty. And yeah, that raises a whole host of issues because also the EU itself, or at least the Commission, is not at this point in time willing to organize a coordinated withdrawal. So the Politico reported in a rather typical title there, EU tries to stop energy treaty exits stampede, and there the commission official was quoted as saying the Commission is not preparing a coordinated withdrawal. The EU will remain a party to the ECT in its own right. Well, that raises the question, can a member state under EU law unilaterally withdraw from a mixed agreement? But also, given the rather obvious political situation right now, where there is a number of member states that represent more than half of the population of the EU that are considering withdrawal from the ECT. that also brings back to the question, can the EU actually withdraw if that becomes a political reality, if there is no political support to proceed with amendments of the ECT, and then the only option is, given that the ECT is incompatible with EU law, to withdraw. So I'm going to make a few my few main points, and then I will discuss a bit of the basics of mixed agreements, and then discuss both the issue of unilateral withdrawal of the EU when there are member states that might want to remain party to the ECT. Is that actually possible under EU law? And then also the issue of unilateral member state withdrawal. So main points. The EU can unilaterally withdraw, and I'll explain why in a minute. It does have a consequence for the member states. It's a bit tied to the specificities of the Energy Charter Treaty. And secondly, I also think that member states can unilaterally withdraw, although they have, of course, under their loyalty obligations, some obligations towards the EU institutions, which, well, I'll get to that in a minute, what that means exactly. But unilateral withdrawal from by the member states does raise issues over the EU's membership to the ECT, and that all has to do with the way ISDS is structured as a competence between the EU and the member states. So some basics that are important, I think, to underline. First of all, the ECT is a multilateral agreement, so not a bilaterally structured mixed agreement, but a multilateral agreement to which both the EU, Euratom, I should mention, I didn't put it in the slide, but also Euratom, and the member states are party. Second point is the ECT currently is incompatible with EU law. That's mainly for two reasons. The fact that there's no disconnection clause. We already heard Konstanze talk about that. But also the fact that the ECT itself does not contain any of the safeguards that the Court of Justice signed off on in Opinion 117. So there's a clear legal issue. Something needs to be done. Either you withdraw or you renegotiate the agreement. So that's basically under EU law the two options that you have. And so why is this a mixed agreement? That's an important question for us. So why is the EU and the member states, why are they jointly a member to this agreement? Well, that has to do with the division of powers and the special nature of the EU. The EU is not a state. So if it wants to conclude an international agreement and be part of the entirety of the rights and obligations of that agreement, it basically needs the help from the member states. It's a bit more complicated than that. There's also member state side, but that's in a nutshell what is the situation here. So basically the EU needs the help of the member states to be able to conclude an agreement in its entirety, because it doesn't have the power to conclude the agreement in its entirety. And that's definitely the case when it comes to the Energy Charter Treaty, because, well, you can look at all the different provisions of that agreement, but it contains investor-state dispute settlement. And that the Court of Justice has made clear in Opinion 215, such a regime in an international agreement can only be established with the member states' consent. Now, there's a bit of an argument whether still facultative mixity is possible based on the OTIF decision, which I think is quite clear that the Court of Justice only clarified, if you will, Opinion 215 in relation to portfolio investment, and specifically did not address the issue of ISDS, and also the framing of the court's position in Opinion 215 is a little different. Even if it would be, let's say, a possibility facultative mixity, I think it is very much a theoretical possibility. Yeah? So this situation where the council would exercise a shared competence, or choose to exercise a shared competence, and therefore you wouldn't need the member states' involvement. Sorry, I lost my train of thought. Okay, so yes, with ISDS. So the question also there is, of course, what then is the legal basis if there is such a thing as a shared competence of the EU, especially for investor-state dispute settlement? I haven't found the legal basis, but it is, of course, quite important, not least to determine the procedure to be followed under Article 218, the voting arrangements in the Council and the involvement of the Parliament, but also, as the Court of Justice always makes clear, it's an indication to the other parties whether or not the EU is seeking to be bound by those aspects of the international agreement. So moving on to the first issue, unilateral withdrawal of the EU. So withdrawal is a rather unique and novel issue, you could say, because it hasn't happened much in the past. So it's really something that's also not heavily litigated, or something that is also clarified in the treaties itself, especially when it comes to mixed agreements. And there's not much in the treaties on mixed agreements, but there's also no clear indication what the procedure is that needs to be followed if the EU would seek to withdraw from an international agreement such as the ECT. However, ACELG and also Hailey-Scosi have argued basically you need to follow the procedure of Article 218, paragraph 6. So it's basically the same decision as a council decision concluding the agreement. So in a nutshell, that means you would have to involve the European Parliament, and the Parliament would need to consent to such a council decision. So I think the option of Article 218, paragraph 9 is also a bit off the table. There are multiple reasons for that. There are textual limitations. I'm not going to go in that in detail. There are textual limitations to the ninth paragraph of Article 218. It would also make more sense to have basically a similar approach to when you repeal a directive or a regulation, to basically follow the same procedure that was necessary to adopt the decision in the first place. So that all speaks for Article 218, paragraph 6. So you need to follow that procedure. Now, the interesting thing is that in a recent opinion 119 on the Istanbul Convention, the Court of Justice has made clear that this decision is entirely autonomous. So the decision to conclude an agreement is entirely autonomous. It cannot be made dependent on basically a common accord between the member states to agree to all together ratify the agreement and then conclude that agreement. So that's basically the Court of Justice says there, when concluding a mixed agreement, the member states and the EU act exclusively within their spheres of competence. Now, from an international law perspective, you can say all kinds of things, but that's basically the view of the Court of Justice. Each does simply concludes their part of the agreement. So that means you can decide this entirely autonomously from the member states. So unilateral withdrawal by the EU is possible. The consequences, however, is that these member states are stuck with agreements that's still incompatible with EU law. And also that these member states, if they would renegotiate this ECT, they would basically be exercising powers that they do not have over foreign direct investment. So the grandfathering regulation doesn't cover the Energy Charter Treaty. So that means that member states really have only one option if the EU decides to unilaterally withdraw, and that is to withdraw themselves as well. Now, when it comes to member state withdrawal, this is a bit more interesting from an EU legal perspective, because you have this duty of loyalty. And so for a very long time, the case law of the Court of Justice was quite general on this obligation. Larik and Delgado Castellero have written a very good article on this duty of loyalty in the context of external relations. Only recently it's a bit more clear what that actually means, the duty of loyalty in external relations. In principle, it means that if you want to do something unilaterally, you have to inform and consult the relevant EU institutions. Now, the question here is, when it comes to withdrawal for the ECT, for the Energy Charter Treaty, if there is a duty to remain silent. In other words, whether there should be something the member states should not act at all, so also not withdraw. And so this duty to remain silent is mainly based on the PFOS case, where basically Sweden unilaterally decided to propose PFOS under the Stockholm Convention as a prohibited substance. And that led the Commission to start infringement proceedings because the Commission didn't want to prohibit PFOS. And basically, the Court of Justice said that indeed Sweden had breached its loyalty obligations by basically binding the EU, or potentially binding the EU on new standards. That's what basically the result was of Sweden's unilateral actions. So in order to have a duty to remain silent, there were basically three requirements. There needs to be an existence of a common strategy. So the EU needs to have some kind of strategy developed that that member state, by its unilateral actions, would disassociate itself from, and then that would have legal consequences for the EU. Now, Hailey-Scosi has argued PFOS, you should really see it as something specific to that case, specifically because the EU would be forced to basically adopt these new rules that Sweden would want to propose under the Stockholm Convention. So bearing that in mind, we should, I think, and it's a bit of an open question whether withdrawal, unilateral withdrawal, actually results in a disassociation from a common strategy that would have legal consequences for the union. And I don't think it's that evident that that's the case. First of all, there needs to be a common strategy. So if as soon as the council votes down the commission proposal, we could say there's no common strategy anymore. Then secondly, when it comes to disassociation with negative consequences for the EU, we cannot interpret this as completely doing away with the division of powers between the EU and the member states. So if the option is after like this, let's say the common strategy continues, so the council votes in favor of proceeding with the Energy Charter Conference, if the option is either accept the amendments or vote against, if that would be the options, that would actually be disadvantageous to the EU's position, because the EU, if the EU strategy would be to adopt the amendments, it would need 3/4 of the parties of the Energy Charter Treaty to adopt these amendments. If you remain a party to the Energy Charter Treaty as a member state and you vote against these amendments, that would make it harder for the EU strategy to materialize. So you could even say that the duty of loyalty in this particular instance might actually require member states to withdraw at some point if they know that they do not want to accept the amendments, which is by the way, the case for these 5 member states. So what are then the consequences if member states withdraw but the EU stays apart? Well, so again, opinion 119, each of these parties are supposed to act exclusively within their spheres of competence. So that basically means that the EU is including the ECT for those areas of the ECT which is responsible. I'm not saying that this is like from international law perspective acceptable or whatever, but this is the Court of Justice's perspective. The problem is that there are already indications by the EU's actions and the Commission's actions that the EU is actually acting outside of its competence by accepting basically arbitration under Article 26 of the Energy Charter Treaty. So I made here a few specific points. I'm not going to talk to them in detail because I think I'm already over time, or am I doing quite okay?
We have only 2 speakers at this time, so I think you're.
All right, then we'll leave it open for discussion.
Yeah.
So so those are my 2 main points. Unilateral withdrawal is possible legally under EU law, but yeah, of course, there are huge international law questions and also political questions that relate to that. Thank you.